Okay, it looks like we don't have any audio here in the courtroom. System on, that's it?
Can I have that post-it right there, please?
Of course.
Yeah, that's.
Yeah.
There's something else I need to do here? Oh, this sounds, I think, here we go. Okay, can you hear us at the main jail?
Excuse me, Judge, I couldn't hear you.
Yes, I'm just, it's the first time I'm in the new courtroom, this courtroom, so I just want to make sure the audio's working fine. Can you hear us okay?
The audio is off and on. I know they have construction here, so that kind of interferes. So long as everyone speaks into the microphone, we'll hear everything.
Okay.
Thank you.
Good morning, everyone. I'm Judge DeLuca. Welcome to First Appearance, Broward County Court. Let me just take a moment to remind everybody, everything is being recorded. The nature of these proceedings is a limited proceeding. It's for determination of probable cause and the custodial status pending further continuance or resolution of the case. This is not the opportunity to argue guilt or innocence. Everything you say can be used against you in a subsequent or future proceeding, so it is usually in your best interest to speak to your attorney and let your attorney do the speaking for you. If anyone has a private attorney, so indicate when you come to the podium. Otherwise, I'm going to appoint the public defender for the 17th Circuit for the purpose of first appearance. Purpose of first appearance, but again, if you have a private attorney, let me know when you come to the podium. State, are you ready to proceed?
Yes, Your Honor.
Please state your appearance.
Eric Linder on behalf of the state.
The defense here in the courtroom ready to proceed?
Yes, Your Honor. Brian Reedy from the Public Defender's Office.
And the defense at the main jail, please state your appearance.
Judge Hector Romero on behalf of the public defender's office.
If any of the lawyers care to be heard, don't be reluctant to interrupt me. We have a lot going on at the same time, and I certainly don't take any personal offense to that.
Appreciate it.
Okay. Julie Corberstein?
North Broward.
That's North Broward, Your Honor. Come on in, Julie.
Good morning, Ms. Corberstein. You have a capias for a misdemeanor. I do find probable cause. Bond is set in the amount of $250. Have a good day, ma'am.
Your Honor, Ms. Koberstein indicated to me that she's been living here in South Florida all of her life. She's been working at the same job, telemarketing, for the last 12 or 13 years. She's a graduate of Fort Lauderdale High School. She's kind of hoping that maybe her family or some friends might post her bond. I'd ask the court to consider reducing her bond to $100. It might make it a little easier for her friends and family to get her out.
Your Honor, this is Ms. Koberstein's third capias issued on this case alone for failing to appear in court. I believe the $250 bond is quite reasonable in light of that.
Do you have access to when the most recent failure to appear besides this one was?
Yes, Judge, one moment.
Thank you, sir.
Yes, Your Honor. This capias was issued December 15, 2016, and she also is showing failed to appear. Moment. Looks like it was from October 10th, 2016.
The bond will remain at $250. Thank you to respective counsel. Have a good day,
Thank
Ms.
you, Judge.
Coperstein. Alexis Baldwin.
Ms. Baldwin is present here at main jail, Judge. Great, for next.
Yes, ma'am?
Ms. Baldwin is currently being supervised by pretrial services for case number 17-007788
Judge, we can't hear who's speaking.
CF10A. We ask that her pretrial supervision be revoked.
Pretrial is advising that Ms. Baldwin is currently being supervised by pretrial under 17-007788 CF10A, grand theft in the third degree, and they're seeking revocation of the pretrial status based upon the new substantive arrest. Where is that background noise coming from?
It's here at the main jail. They're doing construction. It's really making it as hard to listen on what's going on.
Yes, sir. Yes, ma'am. 17007788 CF10A. Upon review of the probable cause affidavit, I do find probable cause as to each count.
Judge, I had an issue with count 3, the criminal mischief over $1,000. I didn't see an amount listed. I also think the probable cause on count 6 is very weak, very questionable.
State care to be heard?
Your Honor, as far as count 3, as far as the amount, I would just ask the court to define probable cause for misdemeanor criminal mischief. As far as count 6, the allegations support the elements of the offense, Your Honor, not just the giving misleading and deceptive information, but I believe also attempting to remove the GPS monitor from the crime scene, which certainly was evidence of the alleged crime that her sister allegedly committed.
Anything else by the defense?
No, Your Honor.
Judge, as far as the bond amount pertaining to the new charges, Judge, she's been residing in South Florida her whole life. She is 19 years old. She is registered at Broward College. She's set to start school this fall semester. She works for a labor pool, so it's not work that's constant. Whenever she's called upon, she gets paid by the day. She's been residing at Miami Gardens with her mother for almost her whole entire life. Her mother is the only person that could potentially post her bond. She's a medical assistant. Judge, we'd be asking you on counts 1 and 4 and 5, which are third-degree felonies. Normally, I do third-degree felony. I would ask for a $1,000 bond, but I do understand that she's currently out on pretrial. What I would be asking you, Judge, to consider is setting a bond on each one of those counts for $2,000. That would be approximately plus count 6 and 5. We're talking about almost a $11,600 bond. As far as pretrial, their suggestion as far as revoking pretrial in case number 177788 CF10A. If Your Honor is inclined to revoke pretrial, I'd ask you to take into consideration her ties to the community and her financial resources. I would ask you to also consider setting a bond of a total of $2,000 on that case, Judge.
State have a recommendation for bond on the pretrial revocation?
Your Honor, if the court is inclined to revoke, then I would ask that it be left at no bond so that Judge McCarthy can decide the best way to proceed as far as her future release conditions, if any.
Okay, finding probable causes to 1, 2, the misdemeanor on 3, 4, 5, and 6. I set bond on count number 1 at $5,000. Count 2 will remain at $100. ROR as to count 3. $1,000 to count 4, $1,000 count 5, $5,000 as to count 6. As to the revocation, I do revoke under case numbers 17007788 CF10A, and I set bond in the amount of $5,000 on the pretrial revocation.
Judge, one last request from the defense. I would ask you, would you sign an order allowing us to photograph Ms. Baldwin's injuries?
That is granted. Present the order and I'll be glad to sign it.
My colleague will draft the order.
Thank you, sir. really? This is what we're gonna do on every single one? Oh, that goes, that's right.
Thank you.
Sophie Greenberg?
North Broward, you're on.
Good morning, Ms. Greenberg. You have a warrant for violation of probation. I do find probable cause.
Ms. Greenberg indicated to me she's retaining Brian Greenwald on these cases, on this case, Judge.
Mr. Greenwald here. Are you retaining Mr. Greenwald, ma'am?
Yes, sir.
Do you expect him to be here this morning?
No, I didn't expect him to be here because it just happened yesterday,
Okay.
coming into custody. But I'm sure my mom probably informed him, but I'm not 100%. I haven't called anybody or spoke with anyone.
I'll call him later, Judge, after court.
Thank you, sir. And bond is set on the warrant by Judge Shear at no bond. Have a good day, ma'am.
Good. August 23rd at 8:45, Sophie, okay?
August what?
August 23rd, you go to court on Wednesday.
Okay. I think I appreciate it. And thank you for giving that call to my mom later on, Brian.
You're welcome.
Erica Lovesmith?
North Broward again, Your Honor.
Good morning, Ms. Lovesmith. You're charged with a new substantive charge of possession of cocaine. I do find probable cause. Bond is set in the amount of $1,000. Have a good day, ma'am.
Judge, is it possible that I can be set for pre-trial release? Would you consider that, Your Honor?
Sure. This is Miss Lovesmith's third arrest since May 15th for possession of cocaine. The other two charges are still open.
Still pending? That request is declined at this time, ma'am. Have a good day.
The number you gave me for Chris is not in service.
Tracy Sapp?
Ms. Sapp is here present, Judge. Judge, she declined the services of public defender.
Okay, Ms. Sapp, you're declining the services of the Office of the Public Defender this morning, is that correct?
Yes, sir.
Are you intending on retaining private counsel?
Yes, sir.
Okay. You're here for, let me know if you change your mind at any point in the proceedings this morning.
Yes, sir.
You have a warrant for a violation of probation. I do find probable cause. Bond is set at no bond. Have a good day, ma'am. Okay, Jennifer Davis.
I think she's a medical loan.
Davis is a medical loan, Judge?
Okay, and she was also medically reset previously, correct?
Yes, Judge.
Thank you. Geneva Albuquerque.
Your Honor, that's North Broward.
Thank you, sir.
She is a med reset, but she won't even be coming down tomorrow. The earliest she can get here is Wednesday. She's in an ISO cell for a rule out.
Thank you.
I'd ask you to reset it for Wednesday morning, Judge.
Okay, this will be reset for medical reset. This is a warrant on a violation of probation. I do find probable cause. This will be set for Wednesday morning. Have a
Thank
good
you,
day.
Judge. Thank you, Deputy.
Earl Cherry.
Mr. Cherry is approaching us here at Maine, Judge. The Department of Service Public Defender is going to be hiring his own attorney.
I'm sorry.
Cherry bond was posted.
Mr. Cherry, I understand your bond has already been posted. Is that your understanding as well?
Yes.
And you're declining the services of the public defender?
Yes.
Any other questions of me this morning, sir?
No.
Have a good day. Mark Pagano?
Mr. Mark Papagno?
Papagno?
Sir.
Mr. Papagno, you have a capias on a misdemeanor. I do find probable cause. Bond is set in the amount of $2,000. Have a good day, sir. David Edward Rice.
Mr. Rice is approaching, Judge. This is a municipal ordinance case. The Public Defender's Office does not represent.
Mr. Rice, you're charged with a municipal ordinance violation of an alcoholic beverage violation. I do find probable cause. Your bond is set in the amount of, yes, counsel. Hold on one second. This is crazy.
It's the Spanish interpreter, Judge.
Spanish interpreter is for Mr. German Lara. He's the one with the animal abuse allegations.
Okay. Do we have this noise every morning?
And sometimes,
And nobody thinks this is improper? How does this come back on the playback when we're playing it back to have a record of the
good question.
proceedings?
I don't know. Usually we have the mic on there off, except when someone needs to speak, and when that mic is off, we can hear much better.
But when the mic is off, we can't hear the defendant.
Right, so we turn the mic on when the defendant needs to speak.
Do I have the ability to control it here?
No.
They can hit a button, Your Honor, so you won't hear it while you're speaking, and then it'll just be on when they're speaking.
I'm not so concerned about me speaking. I'm concerned about having an adequate record of the proceedings.
Yeah, no, that's what I'm saying. We won't hear it over here, is what I'm saying. So there's nothing to do about
They
it
can
when.
hit a button, but I don't have a button here.
No, I believe they just have a button over there to control their mic.
Mr. Rice, can you hear me okay?
Yes.
Okay, you have a bond of $25, sir, on a municipal ordinance alcohol violation. Do you understand that?
Yes, sir.
Have a good day, sir. Chad Hall.
Mr. Hull is approaching, Judge. He's here at Maine.
Good morning, Mr. Hole. You have a new substantive offense for petty theft and driving while license suspended. I do find probable cause as to...
Driving record on him.
It appears, Mr. Hole, your license is suspended as a permanent revocation for 4 or more DUIs. State or defense care to be heard?
Your Honor,
Judge, speaking, I apologize, Mr. Linder.
and Your Honor, I didn't have his driving record but in consideration of.
You want to take a look at it?
No, Your Honor, advising that it's a permanent revocation.
Well, take a look at it. I want to make sure we're all on the same page here.
Yes, sir. Thank you, Your Honor.
And if I'm incorrect, don't be reluctant to point it out.
I learned that a long time ago, Judge. Anyways, Your Honor, in light of the fact that even though he's not charged with it, driving on a permanent revocation would be a felony offense, Your Honor, the state is going to request a $1,000 bond on count 2.
Defense care to be heard?
Mr. Romero?
Okay, the bond will be a...
Judge,
Yes, sir?
and speaking, Mr. Hull, I understand now, as far as the state's, I guess why they're requesting $1,000 on count 2. Unfortunately, and speaking with Mr. Hull, his initial intention was to try and resolve his case today. Judge, we'd be asking you at this time to leave the bond as is. He just moved into Pompano Beach, so basically, hold on. He's going to try and contact somebody to post his bond. Just in the abundance of caution, Judge, we'd ask you to sign an order allowing him access to his phone contact so he can contact his friends and family to post his bond, and we'd just be asking you to keep the bonds in place at this time as what the standard schedule says, Judge.
Thank you to respective counsel. Bond is set at $100 count 1, $1,000 count 2. Access to the phone will be so ordered, so long as the jail doesn't find it to be any security risk. Have a good day, sir. Kevin Shelton. Good morning, counsel. Please state your appearance.
George Odom on behalf of John McLaurin's law firm.
And how are you today?
Mr. Shelton's here present, Judge, municipal ordinance.
Mr. Shelton, you have counsel here representing you. Are you able to see that on the monitor?
I can't hear you.
He can't see you.
I'm sorry, I didn't hear you.
Yes, sir. You have counsel here representing you this morning. Are you able to see that on the monitor?
Yes.
Okay, counsel was here bright and early, protecting your interests and doing a good job as he does for all his clients. You're charged with a new substantive offense of trespass after warning. Counsel, care to be heard?
Yes, Judge. First thing I would do before we officially, Mr. McLaurin is officially on the case, I'd ask the court to inquire as to Mr. Shelton's financial status to see if he qualifies for Mr. McLaurin's court-appointed services.
I'm sorry, I can't hear you at all.
I apologize. I'll try to raise
It's
my
not
voice.
your fault. It's not your fault.
No,
sir.
no worries,
This is-
Judge.
This is insane.
First, I'd ask the court to inquire, Mr. McLaurin has an agreement with the city of Fort Lauderdale if the client is indigent to be appointed to their case. So I first need to ask the court to inquire to Mr. Shelton's financial status to make sure he is indigent and qualifies.
Mr. Shelton, are you seeking the services of counsel to represent you in these proceedings?
Am I doing what? I can't hear.
And I apologize to you and everybody else there that somebody thinks that this is the way things are supposed to be. What are they building over there that they can't shut it down while court's in session?
It's the, repairs to the elevator.
Judge,
Repairs to the
as a
elevator?
friend of the court, I know like
It's
about,
all-
I think it was a
it's
month
all
ago,
the way- it's all the way to jail.
there was some construction going on. Some judge called somebody here at the main jail, and they, as a courtesy, went ahead and basically stopped during magistrate session. But I know last week we had the same problem, and right now it's making it very difficult. So I don't know if there's any way you can contact anyone from the main jail, at least temporarily, to halt during magistrate proceedings.
We'll muddle through this morning, but today, but later today, we're gonna try and address this because this is just not the way it should be. Okay, so Mr. Shelton, do you want an attorney representing you this morning on this charge?
For trespassing?
Yes, sir.
Sure,
Okay.
sure.
Are you employed?
No, sir.
Okay. Do you have any money in the bank?
No, sir.
And I don't have a prosecutor here, and I find Mr. Shelton is indigent for the purposes of first appearance. Yes, counsel?
Thank you, Judge. And just for a little bit more clarification, because it's a city of Fort Lauderdale municipal ordinance violation, the state attorney's office doesn't necessarily have a dog in the fight, and the court is able to, under statute, to enter any negotiations requested, being that it is a city case and not a state case, without any, I guess.
Well, as
involvement
counsel
with the
for
state.
Mr. Shelton, do you have a request?
I am, Judge. I'm going to ask, this appears to be a, a trespass from a 7-Eleven on Broward Boulevard. He was issued a no return. I'm just going to ask the court if the court would get involved to resolve this case, and of course, issue a no return to the 7-Eleven.
Okay. Do you want to make a specific request for a disposition?
Adjudication time, sir, will work for us, Judge.
Mr. Shelton, are you on probation for any matters whatsoever, anywhere, under any name?
No, sir.
Okay. Your counsel is requesting adjudication, time served, court costs, and I'll give you 6 months to pay the court costs. Is that something that you're interested in?
Sure, yes.
Okay. Are you feeling pressured or compelled into entering this plea this morning?
No,
How do you wish to plead? Guilty, not guilty, or no contest?
no contest.
Okay, adjudicate guilty, time served, court costs, 6 months in which to pay the court costs.
Thank you, Your Honor.
Anything else,
Thank
counsel,
you.
on
I
this matter?
got one left, Judge Eugene Tucker. He's on page 12 of the docket. Eugene Tucker. He has a pending felony as capias, outstanding capias, as well as a capias on the municipal ordinance case.
What's the name?
Eugene Tucker, page 12.
Is there another stack of cases here, or is this it?
It's all in there, Jordan. It's got to go through, he called it out of order, so it's.
Okay, we'll get it. I appreciate the offer, but let me take one more try at it. I have it.
Again, Judge, I'm going to be asking that you inquire as to his financial status before actually appointing Mr. McLawrence's law office to his case. And what first you got?
Well, hold on one second. We on Eugene Tucker? Is Mr. Tucker available?
North Broward, Judge, I believe.
Okay. Is Mr. Tucker available?
I think he might have been a reset judge.
Well, he also has a capias on a felony.
I think they told me he was a med reset.
Okay. Can I just ask the court then, if that's the case, to set it for tomorrow 8 a.m.?
Yes, sir.
Rollover.
We'll be glad to do that.
Thank you, Judge. That's all I have, Your Honor. Thank you.
Kelly Shefferant?
Judge, I've been informed it's bonded.
Okay, Kelly Shefferant bonded.
Correct, Judge.
Christopher Camarucci?
Mr. Camarucci? Come on up, please. Judge Municipal Ordinance.
Good morning, Mr. Camarucci. Can you hear me okay?
Sir? Yeah.
You have two capiases for municipal ordinance violations out of Hollywood. Do you understand that, sir? Open container.
Yes, sir.
Okay, the bond is on the capias is set at $100 each. Are you gonna be able to, post that bond?
I have no money.
Are you on probation under any name anywhere?
No.
Do you have any other cases pending, sir?
No.
Do you want to try and get these cases taken care of today, or you want me to address setting a lower bond?
Yes, no contest.
Well, okay, so I'll take that as a yes, you'd like to try and get these resolved today. If you enter a plea of no contest, I'm gonna sentence you to 3 days of Broward County Jail credit for the time you've already served, so you probably serve an additional 2 days. Is that something you're interested in, sir?
How many days?
3 days total, you'll get credit for at least 1 day.
Okay.
No contest?
No contest.
Okay. I accept the plea, no contest as to each of the respective cases, 3 days as to each, concurrent and not consecutive, credit for any time served. Court costs, 6 months in which to pay the court costs. Is that acceptable to you, Mr. Camarucci?
What court cost?
Madam Clerk, what are the court costs on the municipal? I'm sorry? $78 on each case. I'll give you 6 months in which to pay total.
78,
On each case, so that's what, $156?
Okay, 6 months?
Yes, sir.
Okay.
That's acceptable?
Yeah.
Have a good day, sir. Bobby Martinez.
Judge, he's here approaching. Mr. Martinez is approaching, Judge. He's here at Maine. He declined his service as a public defender.
Mr. Martinez, can you understand me, sir?
Yes, sir.
And you're able to hear okay with the noise in the background?
Yes, sir.
Okay, stake here to be heard?
Does Your Honor find probable cause? Does Your Honor find probable cause?
Defense care to be heard?
He is the defense.
Oh, that's right. Thank you. I do find probable cause. State?
Your Honor, the state is going to be requesting a bond increase to $2,500. Checking Mr. Martinez's criminal history, it appears he has 2 prior DUIs out of the state of Texas. He He also has 2 prior arrests for DUI out of the state of Hawaii. Both of those were dropped.
Mr. Martinez, the state is asking for an increase in the bond to $2,500 based upon out-of-state prior DUIs. Do you care to be heard, sir?
Sorry, sir, say it again?
The state is requesting that your bond be increased from the scheduled bond of $1,000 to $2,500 based upon out-of-state DUIs. Do you care to be heard?
Do I care to be heard?
You're representing yourself, otherwise your lawyer would be speaking on your behalf.
Negative, not this time, sir. I don't think I can pay it because I have kids and I'm starting school right now. Plus, I'm using the GI Bill for school.
Well, good luck in school. The bond will be set at $2,500.
Your Honor, I apologize. I'd also, in addition to the bond, I would just ask for a condition of no alcohol or intoxicants during the pendency of the case.
Sorry, I heard a voice over here. $2,500, special conditions, no alcohol or no intoxicants.
Count one is 1,000 and where's the other?
I'm sorry, ma'am?
Increasing to 2,500.
$2,500 on one.
25 on one.
Got it? Thank you. Have a good day, sir.
Your Honor, could you call Mr. German Lara out of turn, as the Spanish interpreter is here and they are at a premium?
German Laura?
Mr. Lara's here present, Senor Lara? Judge, he declined to serve as a public defender. He has private attorney, Miss Elena Perez.
No, I don't understand what it was. I can't hear it.
Mr. Lara, are you expecting your attorney to come this morning?
Señor Lara, ¿usted piensa que va a venir su abogada hoy?
No, porque no, mi día de corte es el jueves a las 1:30.
Okay. No, because I'm supposed to be in court on Thursday at 1:30.
Está mi abogada ahí. No te entiendo. Gracias. Ahora. Quería mi abogado presente, Your Honor.
Yes, sir?
I would like to have my attorney present, Your Honor.
Do you have a phone number for your attorney?
¿Tiene el número de teléfono de la abogada?
And not in my mind. No, no lo tengo en la mente así.
I can provide the court with a phone number, Your Honor.
Yes, sir.
It's
Le estamos dando el teléfono.
954-742-7710. His attorney's name is Elena Perez.
Están llamando a su abogada, señor.
Office, may I help you?
Yes, Elena Perez, please.
Miss Bruce is not in the office right now. Can I help you?
This is Judge DeLuca calling from the courtroom. We are on the record and everything is being recorded. and her client, Mr. German Raymond Lara, is here through video conference for his first appearance on animal cruelty cases. Do you know if
This
Miss?
is in the felony case.
Yes, it is.
I just spoke with Ms. Perez, and she informed me that she's not representing Mr. Lara in this case.
Okay. Were you able to hear that, Mr. Lara?
Señor, escuchó eso. Dice la oficina de la abogada que la señora Pérez no lo está representando para este caso.
No me está representando.
She's not representing me?
Es que este es un caso, es que no entiendo por qué estoy aquí, soy arrestado, pues lógicamente, pero mi caso es el jueves.
I don't understand why I'm here. I mean, I know I'm here because I got arrested, of course, but I'm supposed to be in court on Thursday.
Your Honor, do you want me to contact Ms. Perez?
If you want, I can let me do this. Put me on hold for a moment, speak to her, and then if she wants, I'll pick up the phone. You can give me her mobile. I'll call her.
Okay, give me 1 second. Hold on.
El
Yes,
juez
ma'am.
va a tratar de llamarla al móvil, ¿ok? Al celular.
Your Honor?
Yes, ma'am.
Okay, let me give you Ms. Perez's cell phone number.
Okay, go ahead. Yes, ma'am. Okay, and thank you very much. Right.
Elena Perez?
Good morning, Ms. Perez. Judge DeLuca calling from the magistrate's first appearance courtroom in Broward County. We are on the record. Everything is being recorded. Good morning, ma'am. Well,
Good morning.
we have Mr. German Lara for 12 counts of animal cruelty, 12 counts of unlawful confinement, and 12 counts of municipal ordinance for an arrest. This is his first appearance. He indicates that you are representing him on these matters.
I'm sorry, I just want to make sure the interpreter is interpreting what you're saying to his attorney for Mr. Lara.
Thank you, Mr. Linder. You are correct, but let me get 1 second.
Sure.
Now, I can roll this over to 1:30. We have a 1:30 session. If you want to then meet with Mr. Lara in the interim, we could put this on the 1:30 docket, and at that point, the two of you can then come to whatever decision you make between the two of you. Is that something?
If he's able to call me at my cell, and we can discuss the status for Thursday,
Well, this isn't
that
Thursday.
would be beneficial.
Ma'am, this isn't Thursday. Either I'm going to handle this now or I'm handling this at 1:30 today. So you decide if you want to meet with Mr. Lara, otherwise I'm going to have the interpreter inform him that as of now, you're not representing him on this matter. Is that correct?
I would not be representing on this matter. I'm still representing him on the other matter.
Madam Interpreter, can
Thursday matter.
you please advise Mr. Lara that Ms. Perez is on the phone and she indicates that she is not representing him on this matter?
Señor Pérez, señor Lara, su abogada, la señora Pérez, está en el teléfono con el juez y le está diciendo que ella no lo está representando a usted para este caso. Este caso usted tiene 12 cargos de crueldad y causar lesiones a los animales y también de mantener un animal ilegalmente y causar sufrimiento a animales.
Yo creo que ese de crueldad.
Madam Interpreter, what did Mr. Lara say?
I think something about that having to do with cruelty.
That's what he said, I think something having to do with cruelty?
Yes.
That's the verbatim.
Yes, Your Honor, because
Yes, verbatim,
if
but he
if
was
I know
interrupted.
my client, he's probably refuting the cruelty charge, and
Yes.
he does not believe he is
Well, he's-
being cruel.
Well, he's not your client on this case, right? You're declining to represent him? I'm offering to put this case over to 1:30, and that's not something that seems,
If I will be able to speak with him because I'm not able to go visit him. So is he able to contact me?
I don't know,
By phone.
I don't run the jail, and I'm not gonna get involved
If
with
she
the jail.
comes here at 1:30, I can put her on the phone with him.
If you come to the courtroom, Mr. Reedy from the Public Defender's Office is graciously offering, if you care to come to the courtroom, he'll be glad to put you on the phone with him. If that helps you out, if it doesn't, then I'll just go ahead and make the appropriate decisions and ask Mr. Lara if he'd like to reconsider engaging the services of the Public Defender's Office for this morning. Yes, Mr.
Respectfully, also what I could do is, I could write down the number for him, and the deputies have informed me that after this proceeding, that they'll let him use a phone, so then he can actually contact his attorney.
Ms. Perez, you have any problem with me giving Mr. Lara in open court your cell phone?
No, Your Honor.
Le han,
Your Honor, Mr.
le han dado la oportunidad de llamar, señor.
Yes,
The-
counsel?
The office number would probably be wiser.
Okay, and if he could call me, because I'm on my way to my office now, I just came out of court, so I should be there in the next 30 minutes.
La abogada va a estar en su oficina en media hora.
Could I have the number so I could give it to him?
Certainly, 954
954
796
796
1130.
1130. What I'm going to do is I'm going to set this over to 1:30. Maybe we're still at the same point we're at now, but that'll give Mr. Lara the opportunity to decide on how he wants to proceed with counsel.
Van a esperar con el caso, señor Lara, hasta las 11, a la 1:30 de la tarde, para ver si usted tiene la oportunidad de hablar con su abogada, ¿ok? I didn't understand.
Okay, we'll see you at 1:30, sir.
Usted va a volver a la 1:30, señor.
Madam Clerk, put this on the 1:30 docket.
And please have him call me.
Yes, ma'am. Have a good day.
Thank you very much, Your Honor.
Okay.
May I be dismissed, Your Honor?
Can you just inquire if anybody else needs your services, just to make sure?
I'll be happy to, Your Honor. ¿Alguien más necesita servicios de la intérprete? ¿Alguien más necesita la intérprete?
Español? No one else here at Main Judge.
Okay, thank you, Madam Interpreter, for your assistance this morning.
You're very welcome, Your Honor. Have a good day.
Clusius Elias.
Judge, Mr. Elias is here at Main. He's approaching. He declined the services of public defender.
Morning, Your Honor.
Ma'am, your name is?
Yvette Gray. Oh,
Yvette
good morning,
Gray?
Your Honor.
Good morning, Mr. Elias. Is it Miss Gray?
Yes. Miss.
And Miss Gray, what is your relationship to Mr. Elias?
That's my son. Is that my mom?
His son? Mr. Gray, your mom is here. She's been here this morning. She's here in the courtroom. Okay? You're charged with a new substantive offense. State, if you decline the charges, I think justice may be done.
Well, I was just gonna say, no matter what the court does today, I think it's,
Yes,
but,
sir.
Your Honor, I just, if the court finds probable cause, I looked at Mr. Ellis's record. He has a prior theft from 3 years ago. Your Honor, if Mr. Ellis was inclined to resolve the case, the state's offer would be a withhold court cost on all counts, a judicial notice of time served. If he doesn't want to, then whatever the court deems appropriate as far as bond, the state is okay with.
Your Honor, I will take the court costs. If you would allow me to, sir.
Yes, sir. Just give me a moment.
speak? Please, sir.
Yes, ma'am, absolutely.
This is my son.
A little bit closer so you get to the microphone.
This is my son. And I didn't get a call that he was arrested. And nobody told me anything. And I just knew something was wrong because his behavior is inappropriate. He needs medical help. He smokes marijuana, and when he smokes it, his brain cannot take it.
What are you doing?
He's 23 years old, dropped out
Excuse
of
me,
two
Your Honor,
colleges.
she's lying. She cannot speak for me, Your Honor. She does not have my consent to speak for me. And I'm not 23, Your Honor. I'm 22 years old. 10/09/1994. That's my birth date. I'm 22 years old. My mom is a very worrisome person, and there's a reason why I didn't call her, Your Honor, because I didn't want to worry her with problems like this. I'm 23 years old. I'm 22 years old. I'm an adult. I can more than afford to defend myself, Your Honor. What is she trying to make my situation worse for?
Mr. Ellis, so the first thing you're telling me is that your mom is a worrisome person.
Yes, Your Honor.
So have you ever looked at, you know what a dictionary is?
Yes, Your Honor.
If you look in a dictionary and you look under mom, it's a worrisome person that's concerned about her children for her whole life.
I understand that, Your Honor.
I think
but
you can
I'm
look
also-
on, I think you can look on the monitor and know that I'm probably a little bit older than you. And last night when I was at my mom's house, who's gonna be 90 next month, she's still worrisome, okay? And if you look around that courtroom, there's probably a whole lot of people that would like to have their moms here this morning, worrying about them. And they're probably looking at you like you probably should recognize how fortunate you are. So you don't have to give your mom permission to speak. This is the courtroom that I'm presiding over. Yes, ma'am, you may continue as long as you want this morning.
So my son has been in trouble multiple times. Misdemeanor. The last payment I made, to make a long story short, $295 for a court cost for traffic court. I paid all the tickets, everything. I tried to put him in colleges. I tried to send him back to school. He dropped out of college. It's just friends smoking and drinking.
No, we're not.
He has a room, a decent room, a fridge full of food. I have money in the bank. I hand it to him. He write off 2 cars. It's all about smoking. So I'm here this morning to ask if my son can be in a program to be rehabilitated, because I don't want to see him on the street. And if he continues like this, I won't even get the privilege to stand in a courthouse. Maybe he end up dead, or he's gonna end up in a big prison where I can't even see him. He doesn't have a mind of his own. He has no direction, no focus. My sisters, they would run with me to go to court. None of them want to come this morning because it's just one thing. He's not listening.
And I imagine, Your Honor, if the court is not inclined to resolve the case, and if Mr. Ellis was willing, I believe he would be eligible for misdemeanor drug court with Judge Zeller as well.
Mr. Ellis, are you interested in having your case transferred to misdemeanor drug court with Judge Zeller, who brings a tremendous wealth of knowledge and experience to the division?
I understand that, Your Honor, but I'd like to decline that.
Yes, sir. Anything else? Okay, I do find probable cause. I'm going to leave the bond at $100, and I decline to entertain a plea this morning. Mrs. Gray, I want to thank you for coming. I wish you the best of luck, and I'm sure there are a lot of people at the jail that wish you had adopted them. Have a good day, ma'am. James Anastasio.
Mr. Anastasio? Oh, he's here? Mr. Anastasio? Anastasio? Is that you? On recall. Oh, Judge, can we put on recall? He's all the way in back. I just been.
Yes, sir, absolutely. Jason Osborne.
Hey, Mr. Osborne is here present, Judge. He declined the service as a public defender, but he's asking if his bond has already been posted.
Well, let's take care of the preliminaries. Mr. Osborne, you're declining the services of an attorney from the Public Defender's Office for the purposes of first appearance this morning,
Yes.
and you're representing yourself on this matter?
Yes.
I do find probable cause. You have two counts, DUI and unlawful blood alcohol. Bond is set at $1,000 on count one, $500 on count two. Mr. Osborne is inquiring if the bond has already been posted.
And, Your Honor, the only additional release condition I would be requesting is an order of no alcohol or intoxicants during the pendency of the case.
Jail, I'm sorry, I wasn't able to hear you, not through any fault of yours.
JMS, I have to be up.
Has the bond been posted?
I was checking, Judge, it had
Okay.
came up an error, give me one moment.
Yes, ma'am, take your time.
As of now, no. No bond has been posted.
Mr. Osborne, the bond has not yet been posted. Have a good day, sir.
Is Your Honor issuing the
Yes,
request?
no intoxicants,
No alcohol.
no alcohol during
you,
the
Judge.
pendency of the case pending further order of the Court of Competent Jurisdiction. Edward Smith?
Mr. Smith is here present, Judge, in Maine.
Mr. Smith, you have a new substantive charge of disorderly intoxication, resisting an officer without violence, and corruption by threat. I do find probable cause as to each count. State care to be heard.
Your Honor, if I could just inquire of pretrial release services, if Mr. Smith has, if they have any notes, if Mr. Smith has a criminal history?
1 second, Your Honor.
Yes, ma'am, take your time.
He has priors out of the state of Massachusetts, 2009, assault and battery, disclosed unknown.
We couldn't hear anything.
2009 salt and battery out of the state of Massachusetts. The disposition is unknown.
Your Honor, the state would be requesting a $2,500 bond on count three.
Judge, respectfully, and speaking with Mr. Smith, the 2009 incident, which I believe pretrial talked about, was dismissed. And speaking with Mr. Smith, at this time, he's been residing in South Florida for over 4 years. He's 51 years old. He's living in Boca Raton. He's a caregiver to an elderly person, Judge. He's been doing that for approximately since July of this year. Part of the benefits of that employment is he's provided food and housing. He's given a stipend of about $200 per month. Financially, though, he has no money and no property. Judge, considering his lack of any criminal convictions or anything like that, Judge, and his limited financial resources, we'd be respectfully asking you to set a bond of $1,000 on count three.
I want to thank respective counsel for their input. Bond is set at 100 count one, 500 count two, $2,500 as to count three. Have a good day, Mr. Smith. Peter Larson.
Mr. Larson is approaching. He's here at Maine. Judge, he declined to serve as a public defender. He has private counsel, Mr. Tom Johnson.
Mr. Larson, do you have Mr. Johnson's phone number by any chance?
No, I don't. I was hoping maybe somebody might have that on record around here.
Mr. Linder.
I'm going to try to find it on the Florida bar, Your Honor.
The state attorney is offering his assistance to help look it up.
All right.
Your Honor, does, if you can inquire if Mr. Larson knows where Mr. Johnson practices out of?
Do you know what city his office is in?
Pompano Beach,
Pompano?
and, yeah, and it's 2450 East Atlantic Boulevard.
Okay, let me try another. Is it Thomas Whitney Johnson? Does that sound familiar?
Is that
Tom-
showing Pompano?
Yeah, East Atlantic Boulevard,
Give me-
office 301.
Well, give me the phone number.
954-942-6633.
That's it.
Okay.
Good morning, John Stevia.
Yes, is Mr. Thomas Johnson available, please? This is Judge DeLuca calling from the courtroom, first appearance. Everything's being recorded.
No, he's not here right now.
He has a client. We're doing first appearance, and Mr. Peter Lawson is indicating that Mr. Johnson is his attorney. Can you help me out?
No, I don't know anything about that.
Yeah, do you want to call Mr. Johnson and see if he knows anything about it?
Thomas W. Johnston?
Is he a criminal defense attorney?
No, he's not.
Okay. It might make, Mr. Lawson, can you help us out? Larson,
Larson.
I have the Tom Johnson that we called. It appears that he
Yeah.
does not do criminal defense work, and they don't know
All right,
anything.
so
So is there anybody else that we may need to reach out to?
I would like to talk to Tom and let him recommend it.
Well, let me get this gentleman off the phone. Sir, thank you
Okay.
very much. We looked up the name on the bar directory. I'm sure there are other Thomas Johnsons, and have a good day.
Thank you. Sure, bye-bye.
And
Mr.
just,
Larson, do you want me to roll this over to 1:30 today and give you some opportunity to
Yes, sir.
try and make some phone
Yes,
calls?
sir.
Okay.
If there's a phone here that I can use.
If they can accommodate you, that'll be nice. If they cannot, we'll deal with it at 1:30.
All right, thank you.
Thank you. Madam Clerk, reset Mr. Peter Larson to 1:30. Okay. Dominic Furia.
Judge, when you have an opportunity, brought Mr. Anastasio, so whenever you're ready, we're ready on him.
Okay, let's take Mr. James Anastasio right now.
Mr. Anastasio, come on up, please.
I have a bond.
Good morning, Mr. Anastasio. You're charged with possession of paraphernalia. I do find probable cause. Bond is set in the amount of $100. Anything?
Thank you, Judge.
Have a good day, sir. Dominic Furia.
Furia, come on up, please.
Mr. Furia, you're charged with trespass, and you have a warrant for probation violation under case number 16007267 CF10A. On the new substantive charge, I do find probable cause. Bond is set at $100, count one, no bond, count two, till we have a court appearance on the probation date. Hold on, Mr. Furia. Do we have a court date on the probation violation?
Looks like August 28th at 9 a.m.
August 28th, 9 a.m. Have a good day, sir.
Good luck, sir.
Jermaine Anthony Lynch.
Mr. Lynch?
Mr. Lynch, you have a new substantive charge for trespass and also have a violation of probation. I do find probable cause. Bond is set at $25, count one, no bond, count two, and do we have a probation violation date?
Looks like August 23rd at 8:30, so
August
Wednesday
20
morning.
August 23rd on your VOP. Thank you, Mr. Reedy. Have a good day, sir. Willem Semilius.
Mr. Semilus?
Good morning, Mr. Semilius. You have a violation of probation warrant. I do find probable cause. Bond is set at no bond. Do we have a violation of probation date?
8:23, 9 a.m., Wednesday morning.
Wednesday morning, 8:30 on your VOP. Have a good day, sir. Thank you, Mr. Reedy. Carlos Spancom.
Mr. Buncombe?
Mr. Bonkum, you have a new substantive charge for suspended license. You have warrants for leaving the scene, driving while license suspended. I do find probable, and violation of probation or community control under case number 11004963 CF10A. I do find probable cause as to each count. Bond is set at $100, counts 1 and 3. No bond as to counts 2 and 5. Have a good day, sir.
Hold on, sir. She said I deny it. Deny what? Hold on.
Yes,
Judge,
sir.
I believe in count 2, he would be entitled to a bond.
Yes.
State have a recommendation?
One moment, Your Honor.
As to count 2, bond will be set at $100. Have a good day, gentlemen. Okay. Franklin Blumberg. Franklin Blumberg, possession of prazolam, possession of cannabis, and a municipal ordinance violation. I do find probable cause. Bond is set at $1,000 as to count 1. Have a good day, Mr. Blumberg.
Respectfully and speaking, Mr. Blumberg, what we'd be asking you to consider is a pretrial release. He lives with his sister in Fort Lauderdale.
Hold on, counsel. Was Mr. Blumberg interviewed by pretrial?
Yes, Your Honor, we were unable to verify his address.
Unable to verify his address?
Yes, Your Honor.
State, do you have any objection to pretrial if pretrial is able to verify the information?
No, Judge.
Okay, pretrial is ordered pending verification of the information. Otherwise, in the interim, bond is set at $1,000.
Thank you, Judge.
Nicholas Sovereigns.
Mr. Summers is here present, main judge.
Mr. Sovereigns, you have a violation of probation or community control warrant. I do find probable cause. Bond is set at no bond. Mr. Reedy, do you have a date for us?
August 23rd, 9 a.m.
The next hearing, August 23rd, 9 a.m. Have a good day, sir. Steve Brain.
Mr. Brain is approaching, judge.
Upon a review of the probable cause affidavit, I find probable cause. State care to be heard.
Your Honor, on count 1, the punishable by life offense, the state would be seeking a no bond hold at this time, arguing under a SAZA v. State for first appearance purposes only that there is proof evident or presumption great that Mr. Brain committed the offense. Your Honor, the elements, the facts alleged in the probable cause affidavit would satisfy the elements of burglary with battery. Additionally, there are 2 witnesses who corroborated the victim's version of events and identify Mr. Brain.
Defense care to be heard.
Yes, Your Honor. What the state is asking the court to do is find proof evident presumption great, which is the highest standard that we have in criminal law, higher than proof beyond a reasonable doubt. They're doing that based on a probable cause affidavit and nothing more. They've introduced no evidence. They've called no witnesses. I don't know what the connection is between these people. It looks like an ex-girlfriend, ex-boyfriend type of scenario. Who knows what motivations each individual on each side has to manufacture the truth. There's no sign of injuries on the victim. The evidence here is not nearly as comparable as it was in the case of Uzaga. where there was a great deal more evidence linking the defendant in that case to that allegation. And although the appellate court did say a court can find proof evident presumption great based on a probable cause affidavit, it didn't say it had to. And this is not the kind of case where that should be done. Probable cause, I understand. A bond, I understand. But to hold Mr. Brain without bond at this time, based on what the state has produced here, is insufficient. If the state wants this court to impose the most severe pretrial restrictions it possibly can on Mr. Brain, which is to hold him without bond, they should do more than just give you a probable cause affidavit. They should have some people here. They should have some evidence to present. And they have failed to do any of those things, so I'd ask the court to set a bond for Mr. Brain in this particular case.
Thank you, Mr. Reedy. Anything else by the state?
Just lastly, I'll make it very brief, Your Honor. Just referring to Isaza out of the 4th DCA, the court is very clear that a probable cause affidavit based on the allegations contained therein will suffice for finding a proof evident or presumption great. And also, I would note, I believe the evidence in this case is stronger than the Isaza case, and that there are 2 other individuals other than the alleged victim that witnessed the incident and provided statements to law enforcement. And, Your Honor, I just, for clarification, it does mention the relationship. There is no boyfriend, ex-girlfriend relationship between the defendant and the victim's girlfriend who was present. I believe Mr. Brain is a friend of her ex-husband.
On the argument to respective counsel, the court within the 4 corners of the charging document does in fact find proof evident and presumption great upon a very well-prepared probable cause affidavit. Bond is set at no bond. Have a good day, sir.
Your Honor, in abundance of caution, we just asked also for a condition of no victim contact.
And no victim or witness contact pending, directly or indirectly pending further proceedings or order of a court of competent jurisdiction. Have a good day, sir. Terrence Spence.
Mr. Spence is approaching, Judge. He's here at Maine.
Good morning, Mr. Spence. You have possession of methaqualone. I do find probable cause. Was Mr. Spence interviewed by pretrial?
He does not have a verifiable address, Your Honor.
I'm sorry, ma'am?
He does not have a verifiable address.
Okay. Pretrial indicates that Mr. Spence does not have a verifiable address. Bond is set at $1,000. Have a good day, sir. Danny Padmore. Good morning, Mr. Good morning, Mr. Padmore. You're charged with carrying a concealed firearm. I do find probable cause. Bond is set in the amount of $1,000. Have a good day, sir. Stephen Kryakis.
Judge, respectfully, in speaking with Mr. Padmore, what he informed me is he wanted to try and contact his family to post his bond, but unfortunately he doesn't have their phone number. When he was arrested without his phone. Judge, what we'd be asking you to consider is releasing Mr. Padmore on pretrial release.
The request for pretrial release is declined by the court. Have a good day, sir. Stephen Kryakis.
Mr. Kryakis, come on up, please.
Mr. Kryakis.
Oh, Syriac.
Syriac, sorry. Mr. Syriac, you have a new substantive count of grand theft auto. I do find probable cause on that count. Bond is set at $1,000. You have 3 warrants on violation of probation and community control. No bond on each of those. And do we have a hearing date on the violations of probations? It'll be on 8/20, it looks like 8/22 for your first hearing. Have a good day, sir. Thank you, Madam Clerk.
I know, a lot of them we don't need.
Scott Lagas.
I've been advised, Mr. Lummis Pestro, medical loan, Judge?
Okay, medical reset?
Yes, please.
Okay. Anything else on for the morning docket by the state attorney?
Nothing additional from the state.
By the attorneys from the Office of the Public Defender?
Passing this guy too.
And not here at Maine, Judge.
Not at the main jail, clerk, probation, pretrial. Okay, we are in recess till 1:30. Have a good afternoon, have a good day, everyone.
Thank you, Judge.
The Eclipse docket.